And we move on to the next petition, which is 853.
If you are interested, you can keep the
853 by Matthew Spiegl on behalf of the Free Morgan Foundation on alleged non-compliant implementation and infringement of Council Regulation 338. In other words, endangered species of fauna and flora. The petitioner has traveled from very, very far away. Believe it or not. We are not talking about Europe anymore. We are talking about California and New Zealand, especially for this meeting. You are most welcome. And that has never happened during my time as chair of this committee, that we have so far away guests. So I admire your stamina and your resilience to travel so far, and also your commitment to this issue. So Mr. Spiegl and Dr. Ingrid Visser, the floor is yours for 10 minutes at least, even a little bit more, I think, because we are not in a time constraint at the moment.
Thank you.
So we look forward to your presentation.
Thank you. We appreciate the opportunity to appear here, and I'd like to introduce myself first and my colleague Matthew as well. So I've been studying whales and dolphins and porpoises, collectively called cetaceans, for over 20 years now. And as you mentioned, I've travelled all the way from New Zealand, but I have dual citizenship. I'm also from the Netherlands. So I've been involved in this particular case with the Free Morgan Foundation since 2010, and I'll tell you a bit about her in a moment, Morgan herself. And then Matthew, who is the legal counsel for the Free Morgan Foundation, as you mentioned, has travelled all the way from California. And he's on the board of directors also as part of the Free Morgan Foundation. So the third one that I'd like to introduce you to is Morgan herself. So Morgan is a wild-born orca. Her story is incredibly complex. She was found off the coast of the Netherlands, and she was taken into captivity. And I could spend hours talking to you about that, but at the moment what I want to do is just focus on the complexity of the case, but bring that down to the petition itself. So there's multiple players in this, including countries within the EU and countries outside of the EU. And in this particular petition, we're looking at the situation from Morgan's transfer from the Netherlands into Spain, and that required a certain documentation. And that documentation fell under, amongst many other laws and regulations, the CITES Netherlands Flora and Fauna Law for protected species. And one of the caveats of that is that Morgan, or any species, any individual of her species, can only be kept with the goal as release into the wild. But if she couldn't be released into the wild, the other option was that there was to be scientific research that was conducted with her. Now, in order to transfer her, she required a transaction-specific certificate. And the European Commission for the Environment states that those certificates are issued for greater scrutiny of commercial activities involving Annex A species. So Matthew will speak to you a little bit about the Annex A species. However, the important thing to note from my point of view is that these transaction-specific certificates are issued as a way to allow deterrence of the laundering of wild specimens into the system of captivity. And this is very, very important. So Morgan herself was the first wild-born orca in 13 years to come into captivity. And that's not 13 years in Europe, that's 13 years in the whole world. So she's an incredibly valuable individual because of the new bloodlines that she brings into the system. And to give you an idea about what sort of money we're talking about, the captivity industry themselves claim that these animals are worth anywhere from $1 to $10 million US. But Morgan, because she had that new bloodline, was potentially up to twice that. So anything from $10 to $20 million, making her one of the most valuable individual animals in the whole of Europe, if not in the world. So to put that into the context of Europe, there are only 10 orca in the whole of Europe, and Morgan is the only one that is wild-born. And the EU takes wildlife trafficking very seriously, so much so that they have set up their own action plan. That action plan encompasses the fact that they consider that wildlife trafficking has become one of the most profitable criminal activities worldwide. They have 3 main thrusts for the wildlife action plan, and that's greater enforcement, better cooperation, and more effective prevention. And that also involves better enforcement of the rules of wildlife trade. Now, most of us might consider that wildlife smuggling, wildlife trafficking is poaching out in the forest, or that it is smuggling animals through customs in a suitcase. But it's also worth considering that wildlife trade can involve selling tickets to shows, and it can be conducted by people wearing suits and ties. Now, we know for certain that animals that are rescued, whales and dolphins that have been rescued, 13 different species have been used in commercial situations when they've been taken as rescued animals. Within the EU, at least 3 different species. This isn't individuals, this is actual species, so there's multiple individuals within this. Now, Morgan herself, although we recognise that the petition here is not dealing with welfare, the actions that you as the Commission take have real-life implications for these individual animals. The damage that you see here is self-inflicted. This is self-harming that Morgan has done because of the stressful situation that she's been held in. The brown marks are bruising from banging on the side of the tank. You can see the open wound as well, and her teeth have been worn to the gums from chewing on the concrete. So Matthew will now speak to you about the laws and the legislation around the issue of keeping Annex A species in captivity, Council Regulation 338/97. Thank you.
Thank you, Ingrid. Madam Chair, thank you. Members of the committee, thank you for allowing us to come and speak and giving us the extra time. It's greatly appreciated. Give me 1 second to get my presentation loaded up. So we're here today with 3 basic requests. 1, we ask that you keep the petition open. We ask that you instruct the Commission to revise the EC certificate template that we're going to be discussing. And ultimately, we'd like to see the matter referred to the Court of Justice for a definitive interpretation of EU law, as this forum and these issues not only apply to Morgan, but to any wildlife being traded within the EU. So it's very important. We exposed the Commission's transposition errors using orca as our case study. So in the eyes of the law, not all orca are created equal. Annex A, or wild-born orca. Annex B would be captive-born orca, and those are afforded different rights and protections under EU law. So Annex A, wild-born specimens, are prohibited from being used for primarily commercial purposes. Council Regulation 338/97 is the basic regulation which implements CITES within the EU, and we're specifically focused on Articles 8.1 and 8.3 of the regulation. So Article 8.1, display to the public for commercial purposes, use for commercial gain of specimens of the species listed in Annex A shall be prohibited. Full stop. That's the starting point for any trade, any use of an Annex A specimen in the EU in captivity. Nothing can be done unless an exemption is granted specifically. Article 8.3 provides for certain exemptions. So it says exemptions from the prohibitions may be granted, they don't have to be, by issuance of a certificate on a case-by-case basis. So it's very restrictive, and it's supposed to be the exception, not the rule, to grant these exemptions. So under Article 8, 338/97, we focus on Exemption E, which is for advancement of science. 8.3F is addressing breeding or propagation. And Article 8.3G, which is for research or education. Morgan's certificate was issued under Article 8.3G. And again, you see the display of the certificate there. It's a two-sided certificate, but a single page. And part of the problem is maybe the simplicity of that document itself. So in 2001, in an Advocate General opinion of the European Court of Justice, it was stated that according to the court's case law, derogations from general provisions are to be interpreted restrictively. And this also applies to Article 8.3, which provides for a derogation from the general prohibition contained in Article 8.1. So very restrictive, very narrow. The implementing regulation is 865/2006, and the certificate was Annex 5 form, which is a template provided in that regulation. It serves a dual purpose. It serves as the exemption certificate for the 8.3, E, F, and G exemptions, and it also serves as a transfer permit under Article 9.2 of 338/97. So again, Morgan is our case study. Morgan, wild-born, female, Annex A, transferred from the Netherlands to Spain using this document. And on the document, the whole part of the exemption certificate is really contained on one line. That's line 18.8. So the transposition errors from the basic regulation onto the annex form resulted in a commingled / condensed / unintelligible description, combines E, F, and G onto line 18.8. The actual line on the certificate states, are to be used for the advancement of science / breeding or propagation / research or education or other non-detrimental purpose. That is the actual syntax displayed. It just runs together. The same transposition defect was carried over when the form was revised in 2012. The exact same problem continues today. In a recent court ruling from the Dutch District Court issued on the 26th of April in a case involving our organization, the court noted that Morgan's certificate was issued on the basis of Article 8.3G of the Basic Regulation for Research or Education, not any other exemption. So the consequences of the problems with this transposition is that to have the exemptions granted clearly understood, they have to be plainly stated. And on the form being used and created by the Commission, they are not plainly stated. And this leads to confusion. So the Dutch and Spanish management authorities both cite line 18.8 of Morgan's certificate as the sole document that they rely on to reach the position that breeding Morgan is not prohibited, even though breeding is not a part of the exemption that Morgan was issued, which was research and education. Breeding comes in the previous exemption format. It doesn't carry over and it's not alluded to being continuing in the same one. So the Dutch court actually stated to this issue recently and said on the EC certificate, the court finds that this wording in conjunction with the basic regulation, that this is a contraction of the exemption conditions, F, breeding and propagation, and G, research or education. So even the Dutch court is now agreeing in our interpretation of what this line on this certificate represents. So for CITES management authorities to be able to enforce and understand what is authorized and what is not for enforcement purposes, they're compromised because they can't look to the certificate and know exactly what was actually authorized because everything is on there in one checkbox. And that leads to mischief. So Morgan is pregnant. When we first submitted our request to the Commission in 2015, she was not pregnant. And if we had had some action at that time, she might not be pregnant now. The problem with that is that because Morgan is an Annex A specimen, the fact she was bred with a captive-born male Annex B specimen, her progeny, offspring, will be Annex B and can therefore be readily traded in the commercial without restriction. That's why she's so valuable. So deterring the laundering of wild specimens into the system is very real. It's very real in this case and in others. To deter that, sanctions are required and they're provided in the basic regulation. It's a mandatory issue of sanctions. What those would be are open-ended, but sanctions still have to be provided if an unauthorized use of the specimen is determined. So again, our three requests: keep the petition open, ask the Commission to revise the EC certificate, and to refer the matter for a definitive interpretation of the basic regulation and how it was initially put into the implementing regulation so we can have understanding throughout. Thank you.
And just before I give the floor to the Commission, let me just tell you that this committee has no rights or abilities whatsoever to refer the matter to the Court of Justice. It's the Commission that can do it if they so wish. But we have absolute no possibilities of referring any case anywhere. We are a non-judicial committee.
I understand it.
Yeah, but it's good to see your wish list.
Right, thank you.
So, by having stated that and made it very clear so that you're not disappointed with us, I am giving the floor to Mr. Rodriguez Romero from the European Commission.
Thank you very much, Madam Chair. First of all, I would like to stress that the provisions in question do not relate to the Convention on International Trade in Endangered Species, do not relate to the implementation of the Convention of International Trade in Endangered Species, but to stricter domestic measures agreed in the EU, so the EU Wildlife Trade Regulation. So we are talking about this compliance with the EU regulation. We note that, as pointed out by the petitioner, the provisions in question have been in place since 2001. We have, in light of the petition, looked at the implementation of these provisions over this period of time. The Commission has not been made aware in this period of any major problems with the implementation of these provisions. We have not identified any problems in the extensive study that we carried out in 2007 on the implementation of the EU Wildlife Trade Regulation. We have the Member States in their regular reports on the implementation of the EU Wildlife Trade Regulations have not raised this issue as a significant one. Nor, finally, has the Commission so far has been alerted by any other stakeholder on the issue perceived by the petitioners. Nevertheless, and given in light of the petition and given the arguments put forward there, we have consulted with Member States to get additional insight on how they see it now, currently, and the conclusion is that the Member States do not see any particular structural problem with the implementation of these provisions of the implementing regulation. I would like to recall that there are thousands of permits every year issued by the EU Member States, thousands of permits and certificates according to the Council regulation on EU wildlife trade. Overall, we believe there seems to be no evidence at this stage that the implementing provisions challenged by the petitioners or their practical application are undermining the effective implementation of the EU wildlife trade regulation at any significant scale. There are individual cases like the one used by the petitioner to illustrate their arguments, and there are national remedies to address these issues that I believe have been used by the petitioner in the corresponding member states. I would like to recall that the Commission usually does not follow individual cases or situations, but we rather focus our attention on structural shortcomings in implementation. And in this case, the available evidence does not support, in our view, the existence of any significant structural shortcoming in the implementation of the EU wildlife trade regulation as regards these provisions. Thank you.
Thank you very much. I was just curious to find out, who is the father of that child that she's expecting?
Yes, that's a very interesting question. There's 2 adult male orca at the facility that could potentially be the father. Both of them are implicated in aggressive actions with humans. One of them broke the arm of a trainer, dragged her underwater, drowned her, and she had to be resuscitated. She did survive. The other potential father killed a trainer, and we don't believe that either one of those should have been used as breeding stock because of this aggression. And in response to the Commissioner's
let's not take that. I will open the floor for colleagues now to intervene and give the floor back to you afterwards, if you don't mind. So, Mrs. Estaras.
Sí, muchas gracias.
Yes, thank you very much. Javier Almunia also asked to speak. He's the representative of Loro Parque, and he's also the vice chair of an association. But although he was invited to come along, he felt that he was only representative of one park and didn't feel he covered the whole issue. But as he's here in the audience, perhaps we should give him the floor. He is the vice president of the Zoo Association, the Iberian Zoo Association. Anyway, this subject goes back some way now. The Petitions Committee has already adopted a resolution. I personally visited Morgan in the Loro Parque about 3 years ago. Peter Jahr will remember this case, I'm sure, because it was the subject of a lot of debate in the last Parliament, and I visited Morgan 3 years ago. It was the Dutch government that requested the Spanish government to take on this orca. There was a court ruling, and the Petitions Committee felt that everything was in order in the light of that ruling. This subject has come back here, and to echo what the Commission said to the speakers, there's no actual, it's not correct, because there's nothing in the regulation that says that the orca can't be used for breeding. All of
Además,
all of Member States consulted have upheld the Commission's position on this. The latest ruling in Utrecht in the Netherlands says that the petitioners are not correct in their interpretation, and that there isn't any obstacle to the orca having babies. She's deaf. The calves should be due in September. Nobody knows who the father is. She's under careful monitoring and control. CITES in Spain and CITES in the Netherlands are of the same mind on this. So the interpretation of the regulation that is being made here is erroneous, and the interpretation being made of the regulation it is as has been interpreted by the Commission and courts. So we would like to close this matter, celebrate the fact that in September this calf will be born with great care, with every precaution. So we're not quite sure how this orca is going to relate to her offspring, but Loro Parque and everyone concerned is doing everything they possibly can to make sure that everything goes well. And my proposal will be to close this matter, and let's not spoil this happy story, and express support to all of those who are doing everything they can to make sure that this breeding is successful. And I want to stress that the interpretation being given here is not consistent with the Commission's interpretation, with the Court's interpretation, with CITES Holland or CITES Spain. And so I would like to express my support to Javier Almunia, the director of the park, and the correct interpretation that he is making. If Morgan hadn't had the good luck of being taken care of in this way, and she probably would have had a much worse fate.
Thank you very much. Mrs. Evi.
Grazie, Presidente.
Well, thank you, Chair. I don't agree
with what's just been said by our colleague. I really want to support what's just been said by the petitioners. I mean, here we are confronted, are we not, over and above the case that's been forward in terms of the specific legal case there and some of the infringements of that. On top of that, we are actually confronted by an example, a wild example, which was transferred from Holland to Spain and was given a certificate and now is in captivity and is being used for commercial purposes. So I really don't see inside the certificate anything else. That's what the certificate says. So I'm, to be frank, a little bit surprised. I'm in some difficulty to understand what is happening, because this appears to me to be a mismatch with the reality of what should be happening. This is the use of a wild animal which should be protected, and she is being used for commercial purposes. And also, what makes it worse, she's now also pregnant. So I think that these people haven't come for nothing. They've come because, in fact, there is a significant commercial investment going into this particular case. It's being used for commercial purposes. And if I feel myself obliged to say that we have to keep this petition open, and it's also necessary to clarify exactly what the petitioners are asking for. These model forms that are put forward are not clear. They're confusing. They are open to a whole range of misinterpretation. Now, it's true that this committee here cannot ask for an opinion from the ECJ. That is the case. But the Commission can. The Commission certainly can. And in fact, we should be asking them to go forward and clarify the situation with the court, and to give us as much as possible some more clear information, specific clarification that actually fits into the guidelines of the appropriate regulations. That's what we want.
Thank you very much. Mrs. Ayuso.
Thank you very much, Madam Chair. Well, the first thing that has to be said is that if this orca wasn't currently in the Lora Park at the request of the Dutch government, it would be dead because it is deaf. And a deaf orca, I mean, you know that these animals live in pods, in families, and they transmit, they communicate through sound, and she would be dead without this assistance. Anyway, this Free Morgan Foundation keeps coming back with the same argument that we've seen over the 38 pages of the document, is that the EU hasn't correctly transposed Regulation 33897 correctly in the implementing regulations of 865 and 179, saying that the prohibitions of 338 haven't been properly transposed. But they are making their own interpretation here. All the member states, so all the courts that have been involved in the Netherlands have upheld that this is fine. They don't uphold the complainant's position. So it makes no point coming back again and again with their own interpretation of the regulation. And it doesn't say anywhere that an orca that is being held for research and scientific purposes cannot have offspring. If the Commission has supported this reasoning, if the courts see no problems with this, why should we keep coming back to this petition time and again? I think we should close it, because, you know, in X amount of time, people will come back once again saying the regulation is no good and that it has to be changed, and it has to be changed to suit the petitioners' opinions. So I think, you know, what we've done, we've gone far enough with this.
No, I don't have any more members that wish to take the floor, and therefore I'm happy to extend it back to Mr. Spiegl and Dr. Visser.
Thank you very much. We hear what everybody's saying, but respectfully, we don't agree. with the exception, of course, of the supporting member here. The Netherlands District Court on the 18th of April very clearly stated that there was a contraction of the law, that the separate articles had been combined into one, and that there was only a certificate issued for research or education, not for breeding. So it's very clear to us that there is a commercial driving purpose behind why these requests for the petition to be closed are being made by Loro Parque. In our case, we don't get funded by a commercial entity. We donate thousands of hours of our own time. We fundraised publicly to come here. We do not have a commercial interest. We have no benefit from seeing this through. But we do see the benefit for the animals. And we must stress again that this is not just the case for Morgan. There are potentially, as was pointed out by the Commission, thousands of animals that are being impacted by this. And because we have followed this one individual all the way through from the moment she was captured until today, literally, we're able to pinpoint where these errors are. And we believe that many of these other animals, nobody is documenting them and following what's happening to them. Now, the claim was made that Morgan is deaf and therefore she would have died, and that is erroneous, respectfully. There are potentially lots of other places that Morgan could have gone. We had proposed originally that she would go into a sea pen, which is basically a floating pen out in the ocean, and that she would have been rehabilitated. There are sanctuaries being put forward at the moment for whales and dolphins that had Morgan been available earlier, she could have gone into a sanctuary. There's lots of different points that we can raise, and although they say that we have discussed this in different courts and the rulings have been against us, that's also not true. The ruling just recently was all in agreement with everything that we put forward. The only thing that changed at the end was that they said that they weren't going to remove Morgan. So their interpretation of the ruling from the Dutch courts was in contrast to what we found. Thank you.
Very briefly to add on to that, a good starting point, you asked the question, who was the father? Well, the real question would have been who owned the father, because in reality, all the orca at Loro Park are owned by SeaWorld in the United States. Officially the United States government officially recognized transfer of the orca effective December 15th, 2017, long after Morgan was pregnant, long after the conception had begun. SeaWorld owned all the orca, and they even claimed ownership of Morgan on Securities and Exchange Commission documents filed when they went public on the stock market. We have the documentation. The 4 original orca that came, which included one of the potential fathers, came from the United States under a permit, and they've been there. And when SeaWorld implemented a breeding ban, when they decided they were going to stop breeding all their orca, that applied not only to the 3 SeaWorld parks in the United States, it applied to their orca at Loro Park as well. And Loro Park was bound under their breeding loan contract with SeaWorld, which had a section called Standards. And it said if SeaWorld changes the standards, Loro Park was obligated to follow those same standards. The standards included the decision of SeaWorld to stop captive breeding. They didn't want to follow that because they knew the value of selling tickets to their orca, and they wanted to keep orca. They got Morgan pregnant while SeaWorld still owned those orca, while the fathers were still SeaWorld's orca. And there's another whole issue under Article 8.1 that we have not discussed. This is about the permit, and anyone who can defend that line 18.8 as being an accurate interpretation of Articles 8.3, E, F, and G, and understanding the construction and legislation of why you separate certain sections, specifically add different paragraphs instead of just one bulk combination, is what this is all about. With all due respect to the Commission, they are totally wrong, and from America we would call their rendition alternate facts. It's not true. we ask you, please keep this open. They do have a conflict of interest to investigate themselves for an issue we point out has been in existence since they basically created the first implementing regulation. Asking the Commission why they could not refer it out to the European Court of Justice for an interpretation of not this case, but the form and the application back and forth between what was actually in the Council regulation and their implementing regulation is what we really would like to see done. And I think it's a legitimate and proper request.
In my capacity as chair of this committee, I at this moment find myself in an extremely difficult situation. I have too few members to conduct a vote. There needs to be a quorum of 12 members in order to proceed to a vote. I now have members asking for the petition to be closed, other members asking for it to be kept open, and I cannot conduct a vote. There are simply too few members. A quorum requires 12 members in this committee, and we are at the moment 1, 2, 3, 4, 5, 6, 7. And that's it. I cannot conduct a vote at the moment, which means that 8 members at the moment. And we need to be 12, otherwise we cannot vote. And this, we now have diverging opinions, diverging sides, and it doesn't help that the EPP is almost full, because we need to be 12 in order to have a quorum. I cannot conduct a vote, which means that we leave the petition open, and I ask the European Commission explicitly to investigate if there is compliance with the CITES, whether, in other words, if the regulation would allow the breeding of orcas that are in captivity for when the purpose is research and education. And that's what I can do, and we need to come back to this issue on an occasion where I have a quorum at least. Otherwise, I cannot proceed. And that is it. Mrs. Estaras.
Bueno, yo simplemente que...
I'd just like it noted that we have been called to be here for over a month, like the petitioners, that my group, which I represent, is here with 6 members present. We've got EFDD here, but the other groups have neglected their obligations, and right now our group has a de facto majority, although it's not under the rules, and the other group should be here expressing their view, because we have people here from Tenerife, we have petitioners, and respect for the petitioners and Loro Parque, which is taking care of this animal. They deserve MEPs to be here. Right now, my group has a majority, not in accordance with the rules, but it does have a majority. And in order to continue working on animal well-being, and this pregnant orca would require people to be here. So we do have a majority, and people are neglecting their duties, and I want that to be reflected in the minutes. Thank you.
Of course we will reflect this in the minutes. This is what I can do. But I can tell you, I am now a chair of this committee 4 years, and it has never happened before. It has never happened before that I have not been able to proceed to a vote because of the neglectance of other groups, as has been rightfully been pointed out. The Greens are not here. The GUE that asked for this petition to be put on the agenda are not here. And if no quorum exists to allow for a vote, the decision is referred to the coordinators. This is what we need to do at this moment, and this is according to our guidelines. This is the only possibility I see. Mr. Mato.
Gracias, Presidenta.
Thank you, Madam Chairman. Just a procedural question. I must admit I don't know
if a petition remains open, but there's a majority for it to be closed, but if there's not a vote, why is it that we choose the first option, that it should remain open, when actually there's a majority for closing it? I understand that you wouldn't proceed to a vote, but given what's been said, you know, unless there's a rule that says it should therefore remain open, I'd like an explanation of why that's the case.
It would have been very simple if we would have had one opinion now, but we had actually an opinion expressed by Mrs. Evi saying that it needs to remain open, and another expression expressed by your colleagues saying that they want to close it, and that's the moment when you normally conduct a vote. And in this case, I don't have a quorum of 12 members, which means that I cannot conduct a vote. And in order not to be caught up in a catch-22, we follow point 15 in the rules of procedure, which is to keep it open for the time being and refer it back to the coordinators for further decision. Peter.
I just want to request once again that you as chair express your annoyance with the groups not represented here. This is not the right way to go about our work if we take ourselves seriously. If they themselves have requested that a petition be placed on the agenda, they should at least be present for the discussion. So please pass on this message to those groups who are distinguished by their absence today. This is a question of a lack of respect to everybody concerned, including the petitioners. Everybody should be involved for the sake of democracy, especially the ones who've asked for the petition to be on the agenda. So I understand. I feel that your annoyance as well, that you're not happy at the situation either.
I am being put in a very strange position. It never happened ever in 4 years' time that I have the situation in front of me, and the only thing I can do is to preside over this committee according to the guidelines and the rules of procedure, which is that we do the following: we take a decision, refer the issue back to coordinators, and they will decide in the next coming meeting in July, and that's what we do. And meanwhile, thank you for having travelled from so far away, and thank you to all of you that actually are interested in this issue on Morgan. Thank you for what you do, and thank you for what you still haven't done and will continue in doing on location here or elsewhere. So thanks a million, and have a safe trip back.